Heyo, folks! I did not expect to stream again today, but disqualification of Love and Hylton is back on the table. I did not expect this. I did not expect this at all. Let's go back and listen to the final few minutes here.
Any large extent. But
have to end.
Let's listen to Mr. Steele and then listen to what the judge says.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3, 745 Southeast 2D299, 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court. And
oh yeah, I got the copy. I appreciate it. Thank you.
It's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hylton and Ms. Love. And you've inherited a case that has a lot of history and a lot of it bad. And I put into my motion, I could go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement. I don't know if you've read it. So
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the fourth time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify, because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hylton, it was because...
Listen carefully here. When the judge explains her denial of disqualification was only because of they wanted them as witnesses in that regard. Listen carefully.
because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to, and I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back up.
Yes,
Thank you.
thank you.
Appreciate it.
Yeah. What the judge the judge did not accept the proffer from Miss Love about how it happened that Miss Hylton went behind the back of Attorney Melnick. She needs evidence and more testimony backing that up. And I have a really hard time seeing how they can go around that, because they did go behind Melnick's back. They did know. The prosecution's office knew that Mr. Melnick represented Copeland. Just because Melnick may or may not have been bickering about not getting paid does not mean the representation stopped. The prosecution's office, the prosecutors, and the investigators for the prosecution's office, because they are one entity, have a duty to inform themselves from the attorney they know represented a person last. They have to get informed by that attorney if that representation is ongoing. And we know from the transcript of this ex parte meeting that they asserted to the judge that Melnick had told them that he didn't represent Copeland anymore, which is categorically false. Testimony will, in my opinion, will not save them. They need hard evidence, as they need something that eradicates Melnick's emails to them that he represents Copeland. They need something on paper. If they do not have those papers, they should be yeeted as prosecutors. Possibly, in my personal opinion, the entire office, because they are one entity. Let's see here if they are back yet. They are not back yet. They took a brief. This was good for the judge to clarify this about the possible misconduct. She also, in this discussion with Attorney Steele, that she has reviewed some prior things that the prosecution has done, including but not limited to what Ms. Love asserted to Judge Whitaker, that the thing about they need to get us their evidence. That has happened before. And Ms. Love claims, in no uncertain terms, this was a new circumstance, which is completely false. I do not think this judge approves of being lied to by the prosecution in this way. And the way she spoke just before this break shows me at least that it is an actual consideration from this from Judge Whitaker to throw Love and Hylton out. Still, that doesn't mean to dismiss the case with prejudice. Remember that. It needs to rise to that level. It is a slightly
Witnesses for the
stronger
state.
possibility.
Ready? All right, let's get that person on the stand.
United States House Animal Body.
All right. I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining, we're not used to being the witness. And the direct finished, and I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But oh well, maybe Mr. Abate won't do that. We'll see.
Yeah, I don't see how the prosecution can claim by testimony
You're
alone.
coming up to the witness stand.
Like Mr. Melnick, I'm an officer of the court. He's going to swear himself in, but whatever.
All right, let's.
Like Mr. Melnick, I'm an officer of the court.
Who the
wasn't sworn
fuck
in,
is
but
this
yes.
jackass?
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the chief deputy of the Major Crimes Division.
All right, and February the,
Could you please slow down? Spell the last name.
It's ABBATE. And I said
Oh,
chief deputy of
this
the Major Crimes
is-
Division.
February,
This asshole is of the school of Fawny Willis. This is so disrespectful. Now, give me 30 seconds. I need to turn something off over there because I wasn't supposed to stream. I was not preparing anything. I just boom online. Give me 30 seconds. I'll be right back. All right, let's get back to Assistant District Attorney fart face here.
of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on a Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134. It was his possession of a firearm by convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness in this case, 22 SC 183572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182134.
Thank you.
This, this is regarding the disqualification and the motions and stuff like that. This is not a part of the actual trial. So whatever is being disclosed here is only evidence in this hearing. It does not mean it gets into the trial portion. Just for clarification.
Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, her case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing, as a representative, pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again.
I can bet good money that this smug face is misrepresenting what was actually said. I could bet money what Mr. Melnick argued was, why is this jackass here? This is a hearing about this specific case, not about this other RICO case. I can, since my client is not in that yet, I cannot represent him both here and there at the same time. That does not mean he does not represent Mr. Copeland at all.
And he kept making snide remarks as it related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to I guess, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134. And the charges were possession of a firearm by a convicted
He
felon.
studied that just
And I
before he
think
got
reckless
in.
driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction. Because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
It
No, it was the exact
doesn't
opposite.
matter.
The exact same judge that we're sitting before today.
Him referencing this judge is not proper.
And showing what our market states is it too, Your Honor, I don't know if the court had already.
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melvin about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182 134. I was right. So this would have been the product of that conversation.
Okay, thank you. All right, that's all I have with this witness, Your Honor, for right now.
All right. Any questions by any of the defense attorneys for this witness? Nope, nope. Ms. Weinstein, Mr. Matthews, Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State calls Attorney Peter Herzog.
Okay.
When he had that interaction, as he said, that was February 2023. Mr. Melnick testified he had meetings with the prosecution's office in June, where he said to that person, I represent Copeland. So whatever he said on that meeting doesn't matter. Does not matter. And that is probably why they don't ask him any questions, and probably won't ask any questions. They will just bring back to the judge's attention that Mr. Melnick was on the stand testifying about information that this prosecution's office had in June, which this testimony doesn't take away. I mean, this is so bad. And thank you all for being here. The bunch of you, I really, really, really appreciate it that you came over here on such a short notice. Now, I don't mind if you are in any other channel. I will never fault you for that. Not one bit. Cadnot Williams, excellent choice.
It doesn't matter to me.
Infamous
I mean, do
Sylvia,
you want him sworn or do you want
excellent
him to testify in his place?
I haven't sworn you.
All right, yes, please swear him.
Raise your right hand. You swear first testimony you the name the truth, you tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat. Thank you. First name.
Peter, P-E-T-E-R, Herzog, H-E-R-T-Z-O-G. T-Z-O-G.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption unit?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2023?
Yeah, I think it was March. I've been here about a year and a half.
Okay. Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screened cases and then I cover court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Pope?
Yes, I believe so.
At any time during those conversations, did you ever, in any way, seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
It doesn't matter. You cannot specify as a witness like that, because Melnick has already said, I represent Mr. Copeland. I told the prosecution's office in June, just because he wasn't, that case back in February was separated from this case. So them trying to do things on both cases doesn't matter. Does not matter. This is so infuriating.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hylton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we've had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about A case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody within the DA's office to have any communication with Mr. Jones regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
That is such stupid questions. They try to, again, I said this in the previous stream, they try to slice up the attorney represent him there, but he have to explain every single time and every single case that he represents him. No. If you know he has representation in a prior case, you have a duty to inform yourself. It's not Mr. Melnick's responsibility to tell you. It is your responsibility to inform yourself if he does not. This is so infuriatingly stupid.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter.
I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4. And ask you if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating, as part of anti-corruption, we were investigating.
Without getting into the details of any anti-corruption case at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here, I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was when you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did.
He just said that he never reached out to Mr. Melnick regarding this case. Ta fucking da. And nobody did, even though they knew the last case he had representation by Mr. Melnick. Prosecutor Love is now desperate. Once she learned that disqualification is still on the table, she is in complete desperation mode. In my opinion, this doesn't show at all that Mr. Melnick did not represent Mr. Copeland, not for one single bit.
I wrote a check mark, and I'm gonna have to get that off the board.
Okay, probably have some white out. That would work. Is that okay with everybody? If on states 4, Ms. Love wipes out the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence, because I'm constantly taking notes and then I end up writing on the evidence.
And it's defendant Williams exhibit.
Is that okay? All right. Thank you.
With the court's permission, I'll do that after Mr. Sharp has had an opportunity.
Go ahead, Mr. Sharp.
Good afternoon.
Good afternoon.
So from what I understand, March 2023, you are working for the DA's office in anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
He's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witnesses.
Sustained.
What kind of case was this?
Objection as to.
Well, can we just leave that it's an anti-corruption type case?
May I ask?
I forgot. That anti-corruption case is about a cop on the take, which Mr. Copeland is a witness to. Oh, they do not want that disclosed to the public. Who or how many cops was on the take during 2013 to 2016? Because that might ruin their case in this RICO trial.
Was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's
Your Honor.
Yes. Do we need a bench conference? Okay.
And that means sidebar counter 218. Here we go with the sidebars again. Now, this anti-corruption case is regarding one or a number of cops on the take, which I do believe the defense somewhat want in, but also does not want in the trial, because that might show a criminal conspiracy, but it also might show how cops aided during the 2013 to 2015-16. A few of the cases that are in this RICO charge was handled by corrupt cops. Now, we already know, because a few of the bad cops have taken the stand, even though they are not technically under investigation for corruption. And that is may or may not be a reason why only half of them back in the day was pled out, or any of the sort. Hello, Gigi. Everybody say hello to Gigi, my first and best moderator. If anybody wants to say thank you to Gigi with cash, right? If you go to my PayPal and write Gigi, I will refer those to her. For you who have been here for a while, you can explain to the people who haven't been here for a while why I do that from time to time. Hold on while I find
The earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. But one of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you.
Thank you, Liam. I've said for quite some time now about Gaither retiring before she was allowed full retirement after just 19 years, not 20. And according to Liam 007, Gaither and Dennis were the subject of that investigation. They were allowed to quietly retire. That makes sense. That makes perfect sense. But for me, that should also mean, for instance, them being allowed to testify as expert witnesses is just a mockery of the court.
About it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams. Okay. Who else do we have? Mr. Stillwell, you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all can't even get it.
All right, let's skip ahead a bit. And they're back. That's the good thing about stopping for commentary. That also means I can get caught up, so we don't have to watch dead space all the time. Oh, before I forget it. Last stream, I got 2 donations via PayPal. And I didn't see those until after the stream. So first of all, thank you to Kristen L for your $25 donation. And thank you to Diane T for your $25 donations via PayPal. And now, did she say bitch? Well, wherever Miss Love is and talking, yes, that is per definition a bitch conference. Sound back on, Core TV, please.
That they want to ask.
Yes, Your Honor.
And do any of the defendants have any questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you-
As soon as I'm done.
Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail. I'm sorry.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel
Okay,
on any case or was recently represented by counsel.
okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation and the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
But
I have no further questions. Thank you.
Does anybody else have questions?
He turned that around on Prosecutor Love. So, Mr. Beard, you would never contact a defendant or a witness directly, but you would contact the attorney that you knew he represented him last time he was in trouble. Yeah, that's me paraphrasing. Showing that Love and Hylton knew they were doing wrong.
Yes, for Mr.
That
Herzog.
witness didn't work for you,
All right.
did it, Love?
No.
Yar!
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is, maybe I shouldn't know about it. With the court, Mr. Williams has no objection, and if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal, or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but yeah, that's valid. Let's find that out.
Oh! Did he get a good deal in that case because it was going to be a witness on this case? And the prosecution hasn't disclosed it? Oh! Oh! Oh!
So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still,
How are you?
good. How are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is this the question whether I feel comfortable?
Yeah, do you understand Brady and its progeny, what it includes?
Yes.
Okay, and I didn't mean that to be insulting at all, just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland, was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay, and I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay, all right, thank you, Your Honor.
Okay.
Okay.
All right.
That
Anybody
was a
else?
non-issue then.
Mr.
Oh,
Williams?
Got my hopes up.
Okay. Anybody? All right. Any redirect by the state?
No, Your Honor.
All right. Thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
I couldn't put a lot of Mr. Atkins to go outside and check.
Sure.
The first smug witness, yeah, he had a very slappable face. Do not do that. I'm just saying he has a very
While we're waiting
slappable
on
face.
finding that out, y'all.
This witness testified that he would never contact a witness without contacting the person who represented him last.
Well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting. Nothing. Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all here, I think.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that.
Which means the first witness testimony is completely useless because the last contact he had was in March. June, Mr. Copeland was represented. June. End of June, even. End of June. And since Mr. Copeland is apparently out and about, whatever plea deal he took was very good for him because he's out and about. Okay, who's the next poor sucker the prosecution wants to have up there? No worries, Kate. You go over to EDB, watch for members only, and then you can get back here and do with the replay crew. I have no issues.
All right, what do we know,
with
Mr.
people going
Atkins?
over to other channels.
Mrs. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay.
sorry, he said 40 minutes, he corrected.
okay.
And so, rather than have the court wait on that.
Oh, the next
We're gonna do that
witness
tomorrow?
wasn't in the
I can-
court.
Yes, I can do that.
All right.
And Your Honor, the other thing that I was looking at was I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him. Since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the, on June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is their right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay, and Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I asked for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay.
That because it was filed on.
All right. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on, okay, that's what we're getting today.
Okay. And that's in which case? This
22.
YSL case?
Yes.
Okay.
Oh, wow. The prosecution is starting to unseal things. Oh, the desperation.
So I want you to let me know what it is. I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay.
Without the exact date, I don't want to, I think maybe
Directed to
May
Copeland.
31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Hurstfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she going to be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Okay.
I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm going to.
All right. Would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Melnick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right. So that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe 1 or 2 issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Your Honor, I will speak with Mr. Shard.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday before we had all of our more explosive motions put before the court that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe 2 items that you thought you could work out everything, and there were 2 items that were still kind of in dispute.
That may have been Ms. Hylton.
It might have been. I don't know.
Just get him.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes
To line up Ms. Potter.
to line up Ms. Potter and to speak with another member of our office?
Okay, so we will take another break and be back whenever you let a deputy know that you're ready. Okay, which hopefully won't be more than 10 minutes.
Thank you.
All right.
Oh, and this judge wants everybody to be prepared to go. And Miss Love, once she knew that, because she probably did all of this under the assumption that she was never going to be disqualified. And now, the judge says, oh, disqualifications is definitely still on the table. I know you want to see him. Hello, Mr. Jingles. Hello. Look at this happy cat. Look at this happy cat. Huh? He really enjoys me doing this. Hello, Mr. Jingles. Hello. Yeah, this faster clock keeps faster clocking. I mean, the desperation from the prosecution to even start unsealing sealed evidence that wasn't supposed to be brought up to the public. Oh, wow. Wow. I mean, I have never in my 30-plus year career in law, I have, even before this, I have never seen the like. And this, I mean, seriously, if the confidence in the Georgia judicial system the judge now needs to make a ruling that speaks for the public confidence in the Georgia judicial system. And Miss Love keeps giving Judge Whitaker ammunition. Yeah, Rocco said she's going to talk to the next witness. They just said could appear via Zoom. And now that witness is just outside the courtroom. And Judge Whitaker pays attention. Wow. I absolutely. Now we're back to live on the court. I don't know what to say. Usually I'm not the one who's lost for words. You all know that. What's going on with my? I'm not the one. If I have nothing left to say, I normally, especially in lunch breaks and stuff, speak to Kat. She's better at that than I am. I want to be at the present with the court, in the discussions, filing evidence and testimony and witnesses and everything, and try to explain everything. I have no explanation for what's going on here. Ms. Love is now, in my opinion, completely destroying the little whatever confidence or whatever she had with this judge, whatever she started out with is disappearing fast, especially after the more information. And remember, I believe I said this on Friday or Thursday, no, Friday, probably, that she hasn't ruled on Weinstein's motion because it was too well written. And that gave the defense the opportunity to keep adding information. And now Ms. Love is adding information herself by calling absolutely worthless witnesses. The first witness, Assistant District Attorney Fartface, I don't care what his name is, so smug, and had him making a statement regarding March of 2023 has no bearing. Because clearly, Mr. Melnick represented Mr. Copeland after that date. This Assistant District Attorney for the corruption unit was involved with that case, which led up to the whatever deal it was in June of 2023. And he testified on cross-examination that he would never contact a witness directly if that witness had prior representation. Completely disarming Ms. Love of that argument that we don't need to call Mr. Melnick, because as Mr. Love tried to explain, they're trying to slice up, well, he represented him there. That doesn't mean he represented him over in the other cases. You cannot make that assumption. You can never make that assumption. Yeah, I don't know how a prosecutor Love managed to stay a lawyer without this is so basic. This is well understood throughout the judiciary that once you have represented a person, you have the attorney-client privilege applies for the rest of your life, whether or not you represent that client ever again. That's basic. But also, always assume that if you had contact with a specific person and the last time they had representation, you have to assume that representation is still there. And I did not get the notion from either testimony that Mr. Melnick ever said that after this case, I'm dropping Mr. Copeland as a client. No. Yeah, and if you want this as your office mug or home mug, Gigi, just it's in my merch shop. So if you want one of your own, just follow the link. And I'm so flabbergasted that Miss Love actually think those witnesses would help her case. No, not in one bit. And now also the judge has taken notice of prior possible bar violations and rule violations that happened previously in this trial. And now at a certain point in time, when it stops stacking and stacking and stacking and stacking, sooner or later you come to a point where maybe not each of these warrants a dismissal with prejudice, but the combination of them all should. But remember, folks, that bar is so extremely high. So extremely high, it's ridiculous. But I'm starting to wonder, unless Miss Love shows up with a perfect actual evidence, not testimony, evidence, disqualification is certainly up for grabs. And with that, she might even, with the disqualification of the prosecutors, the disqualification of the previous trial judge, and possible Brady violations, those combined might get her to dismiss the case with prejudice. Those in combination. John Comyn, do I think we will have a decision today? No, I actually don't. I wouldn't mind, because I'm still going to the United States, folks. I'm still trying to Houston, New Orleans, Montgomery, Atlanta on the 14th and 15th, and then up via Chattanooga up to Knoxville, Indiana, and then up to Michigan. I will still go into the Fulton County Courthouse. And say, for instance, that the Young Thug trial is gone. I'm going to celebrate with the attorneys. I have to. I think they will celebrate this weekend if anything happens before the weekend. But I want to celebrate with them when I get there on the 14th and 15th. And I want to go into Judge Glanville's courtroom, sit down and just be there. Because as we've seen today with how I will take credit for this, because remember yesterday, I believe, no, on the Friday panel show, when I said Prosecutor Love has a tell, does Catholic schoolgirl skirt tell. Every time she stands up and she's very nervous about something, she does that adjustment to get the skirt under her knees. And today she's wearing pants. Rodney, am I coming to Detroit? I'll be outside of Detroit with Dave over at MLS Law Show. I will be spending time with him, and hopefully sometime in Wisconsin as well. Denise says, Nick, have you made contact with any of the defense team? Yeah. Mainly on stream. I had Doug Weinstein on 3 occasions. And I may or may not have contact with other people. So, yeah, I hope I can meet up with a few of them when I get there. It's Trinton, just got back from the gym. How much do I have to catch up on? Sorry, go back and play. I mean, I can't say it's been an hour of constant revelation about how absolutely screwed up Miss Love is as an attorney. Absolutely screwed up. Rodney Burnett Johnson, judge acknowledged misconduct according to the bar, but the defense will not win by technicality. I don't know. I actually don't know, because she does acknowledge that she has that power by referencing the barcodes and the rules of conduct and stuff like that in order to disqualify Ms. Love and Ms. Hylton. If she gets there, that's another question. In my opinion, we're way beyond. But I cannot speak for Judge Whitaker. Even being here now is a surprise for me. I did not expect today to happen this way, especially not after the morning. This cluster clock that has been going on the afternoon is astounding. That Prosecutor Love, I can't even imagine this looks good for her. Joey's first fan says Weinstein is such a lovely, soft-spoken man. He is. And he's an excellent attorney. And this entire trial rested on Judge Weinstein not making a ruling on his motion to dismiss with prejudice. She allowed her judgment for that to be postponed. And thanks to that, the defense got more and more in. Okay, we seem to be back here.
All right, were you able to get Ms. Potter?
So Judge, my request is that the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
We're missing some defendants.
Oh.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on. I should have looked. There are some empty chairs.
Yeah, we can all go home.
Okay, everybody was not back. It's stringent. They didn't rule out an ex parte before Copeland spoke to. No, I mean, somewhat. There is not enough evidence for the court to acknowledge it. In my opinion, there is, but I'm not the presiding judge. Portland Thunder says, it's mind-boggling for how long her career has been. She's this bad at her job. It's just how bad the courts are. There's that she's never been taught or experienced these issues before. I agree. Oh. Okay, we are. It's almost as if Judge Whitaker has prolonged this in order to allow Prosecutor Love to bury herself. Almost. She made a bunch of rulings in the beginning, but she kept a few outstanding rulings, allowing the defense to get more things in and to allow Prosecutor Love to bury herself. And now she is unsealing evidence that has been sealed for a very long time in order
That's
to
everybody,
save
all right.
herself.
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford case, Ford Motor Company case that we were provided today, and in making our final argument. And to allow us, if we decide the need to call ADA Potter, the main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the three names.
Oh, okay. So you may not need her after all, then
You know,
that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not.
sanction. Yeah, sure. You haven't had a chance to take a look at it. Sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed.
Okay.
Those witnesses was all she had, except trying to reply to the Ford case. And the last one specifically said, I'm not doing this verbatim, that he would never contact a witness if he knew the last time he had representation, which contradicts Ms. Love and Ms. Hylton's argument completely. Oh,
That's
this
fine.
is so bad.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
How will the subpoena to him directly, unless it's signed in May by Mr. Melnick? I don't see how that helps in any way, shape, or form. This is so immensely.
because it has certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland.
That's
and
a week before.
I'll
we
let
went-
you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24-5-507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean.
How are those attached to each other in a sealed envelope? How is Judge Glanville's order in a sealed envelope together with a subpoena? What?
And if so, we can make a copy of it and you can do whatever you want with it from
Well,
there.
it's unsealed now. Hand it over to the defense. Now, I do think it's already in evidence, but why was it in a sealed envelope with this subpoena?
Okay,
Or is this the infamous their application for immunity?
Is that it?
That-
it is. It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think then in the record.
Yes, yes.
All right.
What about
And
your
so what's
application
there
where your
argument you wanted to make
assertion
about that? Or just,
Just that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument
okay.
at the appropriate time.
All right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as,
Wow.
you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch.
Wow.
As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
Directly in the way that he did on.
Okay.
that, yes.
Okay. All right. But we need to make some progress into the, I mean, I am still considering and working through Mr. Shart's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done, that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, y'all need to be thinking about all of the potential ways to.
Judge Whitaker, in between the lines, are more or less telling, in my opinion, Miss Love to get the F out and maybe allow Fani Willis to step in. That's my interpretation.
Handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
Hello, second
And Your
video.
Honor, we did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Sharp, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
Miss
At
Love
some
didn't
point,
pick up on that at all.
Is going to have us to address those, so, and I believe that Mr. Sharp, he can again, correct me if I'm wrong, said that he could go through that was for, I believe, the August 2017 interview, a proffer from Mr. Zachary, and there's an earlier one that I think he said he's gonna go through and, okay, he said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So John, just now, Your Honor referenced if Mr. Copeland chooses to do something different than what he chose to do last time, with respect to testify, I'm assuming the court means plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all have got some, I mean.
That's what I.
Okay.
If she got it on the false
Well.
pretenses,
I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter, or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it. Because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on
Okay.
the 10th,
All right.
11th, or part of the.
All right, which is why I need y'all to get together on it
Okay.
and let's tackle that tomorrow. The nitty gritty of it. Okay. All right. So that means y'all have to do that tonight if you haven't already done it. All right. Anything else before we break for the evening? One more thing. All right, so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly.
Oh, what a
All right, anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning, regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.
All right. Well, we are back to these motions to dismiss, and the way she plans forward does not indicate a dismissal or a disqualification of Miss Love and Miss Hylton, which is a bit sad. Oops. All right, I did not plan to do any of this, but oops, sorry. There. I did not plan to do any of this. But after the fuster clock that was going on before I came live, wow. In my opinion, they are so far beyond dismissal with prejudice. It's ridiculous. But the bar for this in the state of Georgia is so extremely high. It's so extremely high. But I believe we are at least closer than we were yesterday, than we were on Friday, with all this information. So you never know. You never know. Folks, thank you all for being here. Thank you for allowing me to try to translate all of this to you all. And I'm going to send you over to a storm chaser, because there are flash floods regarding that tropical storm or hurricane down south. So you might want to pay attention to that. So I will be sending you over to that one. But thank you again for being here. Thank you for allowing me to do this, and hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? I will do a recap tomorrow. So I will see you all back here tomorrow for that recap. Okay? Bye-bye.